child, if any? What age? So protection is given only on 2 occasions. What is the age on which it is given? So Lordship will have a quick look at Regulation 5. That gives, my lords, Regulation 4 gives child who's fit for adoption, and Regulation 5 gives eligibility for adoptive parents. That's at page 230, my lords. Your lordships will see that man-woman relationships are immaterial. So a man cannot adopt a young girl child. And it is in this manner, my lords, that it has been crafted. Then 2 years of stable married relationship is extremely critical. My lords, that your lordships will find in Regulation 5. My lords, I also want to draw your lordship's attention to, my lords, seniority in Regulation 44 and root search in Regulation 47. My lords, seniority, your lordships will find...
Sorry, Regulation 44 and...
Regulation 44 deals with seniority of prospective adoptive parents. And my lords, Regulation 47 deals with root search. So every child is entitled to a root search, adopted child also. When either if he becomes a major, he is entitled to do that on his own or through his adoptive parents. And my lords, in the entire architecture, only at one place the biological parents' rights is protected. That is Regulation 47, Subregulation 6, where it says that the right of an adopted child shall not infringe the right of privacy of biological parents. This is the only place. So if biological parents wish their privacy to be protected, then this root search will not be given. My lords, I've given in yesterday's compilation a flow chart of how adoptions happen, my lords. My lords, I've given a data also. In fact, I took from CARA data. Your lordships will find that at page 1 of my yesterday's compilation. Roughly, my lords, I've given gender-wise. How many boys, how many girls for the last 8-9 years? How many have been given up in adoption? How many parents have registered? So roughly, to give your lordships an idea, there are about 30,000 parents who are registered prospective adoptive parents waiting for adoption. And the children, my lords, here who are in the pool are less than 1,500. There is a mechanism for, my lords, you have to reserve every prospective, and then, my lords, there is a mechanism for intra-country is the last resort.
Only 1,500 children are available for adoption across India?
My lords, yes. And not yet available. They are in the pool. My lords, because there is a time period that's available for children who are surrendered. The biological mothers or parents can reconsider if they want to. So there is a mechanism that is laid down, my lords. And then they are put in the, my lords, I've given a flow chart also of how adoption happens. It is only through Caring's portal. No interference by humans. It is a portal that is automated, my lords, completely. The option goes to the next in seniority as a prospective adoptive parents. They are given 48 hours. They have to give their ethnic background, their choice, gender choice. My lords, the home study form that's a schedule in this, my lords, in these regulations is so exhaustive. You have to disclose not just your health conditions, income, your parents, your other family members, your children. My lords, it is so comprehensive that because it's important. Where the child is, because there is a process of matching that has to happen. After the parent decides that this child might be fit, there is a matching that has to happen, and it's only after that matching that the child is, my lords, given.
Just a question, out of curiosity. We appreciate how much effort has gone into ensuring that the child is safeguarded in every which way when he or she goes to a home. What is the timeline ordinarily for an application once a party applies, a parent to be applies, and it matures by actually handing over the child to that adoptive parent?
I've given that in my...
Do we have data?
But 3 years...
Do we have data of neglected children who are in care institutions and who are not, of course, not adopted? Do after turning 18 go? I mean, I won't use the word they are turned off, because care institutions don't cater to any adult.
Yes,
at the age of 18, if the child is not adopted or not cared for, in the sense that there is nobody to sponsor her or him, and he becomes an adult.
Yes, ma'am.
What is that? What is the future of that young adult who was a child till then? We have, I mean, there is no data. Actually, there is no data. And if you say 30,000 applicants are
prospective parents,
of prospective parents, then 1,500 only are available.
Yes.
Isn't it a matter for concern that we look into every care institution and there are thousands. We have at least in Delhi itself more than 50.
My lords,
And Tamil Nadu, we have, I think, 250 or so.
My lords, this is the data of, well, if your lordships will see page 2 of my yesterday's compilation of legally freed children available as on 28th of April 2023. The CARA guidelines prescribe a procedure in which the child has to be declared free for adoption. My lords, it's a very razor thin edge walk, my lords. The child is being separated from biological parents, surrendered parents, or orphan, my lords. Orphan also, my lords, there is a provision for family adoption because, my lords, our culture, we are polycentric even in families. There will be nani, dadi, masi, mama, buas, whole lot, my lords, and they have right of, my lords, accelerated rights of adoption for family members. So there is the whole process. If the process is not followed for declaring the child legally free first, before giving up in adoption, it is going to. Okay. I just want to quickly, my lords, just tell your lordships what the rest of my note is. Lordships will just see that, my lords, I have also, my lords, I've adverted to in between the ART and the surrogacy mechanism is also like that. I just quickly want to mention this, my lords, the National Board of Surrogacy and ART, they were referred some, my lords, issues that why are you not allowing donor gametes in a surrogacy? My lords, the answer very clearly that has come from them is emotional bond of the child is very important. We can't even take 1% chance. So they say between the egg, the sperm, and the uterus, at least 2 of them have to be of biological parents. So while ART allows donors, surrogacy, where you're using the uterus or womb of another woman, altruistic, no commercial, because now the regulation is very clear. You can't use donors. Though my lords, Code 5 will deal with those challenges, but the reasoning that has come is that there has to be a strong emotional bond of the parents who are going for these assisted mechanisms. My lords, we have given, I think I've covered most of it, my lords. I would draw your lordship's attention to, my lords, one more aspect. The special provisions with regard to children, to women, my lords, is also something that your lordships will have to look at very carefully. We have made a compilation of, my lords, laws where women are protected by virtue of their married or domestic relationships.
Thank you, Ms. Bhatti.
And my lords, one more thing, we made a chart of these 34 countries which have in some manner recognized their civil unions, though it's a phenomena only of this millennium, my lords. But they have recognized, we made a chart, my lords, we've given a source of that also. 27 of them have gender neutral rape laws. Social fabric is different, my lords. That chart your lordships will find, my lords, in our compilation C at page 1492. The source is also there, my lords. 27 countries gender neutral, 4 are gendered, 3 we could not confirm because they were in languages, my lords. Though we tried AI of the internet to get the sources. My lords, I'm very grateful to your lordships. I had, my lords, just written an opening line. If your lordships will permit, I'll read it, my lords, at my closing. The entire endeavor of ours is to present to your lordships that the architecture of child-centric or child welfare laws is very carefully crafted with welfare of child being paramount. Any general declaration reading in spouse instead of husband and wife will make laws relating to adoption, assisted reproduction, surrogate reproduction completely unworkable. Even for the legislature, my lords, which has the tools of wide consultation, expert and specialist advice, my lords, options of calibrated and gradual solutions, opportunities of amendment, savings and repeal. That to my mind is a very, very important tool, my lords, the option of adoption, savings and repeal. My lords, they will also find it very onerous responsibility to balance on one hand the competing rights and on the one hand protecting the parents' patria responsibility of the welfare of the child, because that is non-negotiable.
All right. Thank you, Ms. Bhatti. Thank you.
I am very grateful, my lords. Your lordships have given me this opportunity.
Yes, Mr. Maninder Singh.
My lord, only a couple of minutes, my lord, because the written submissions are already filed. My lord, if your lordship kindly have, my lord, the written submissions coupled with the small compilation of judgments, my lord, which are in our name. Because I tried to find out the PDF number. I was instructed, my lord, to.
We have the written submission.
Yes, my lord. Now, I have only 2 points to make, my lord, in support of the same submission.
What are the 2 points? You
Yes,
can just
my lord,
highlight
first
them.
of all, on the point, my lord, that under section 4 of the Special Marriages Act, by virtue of, by process of interpretation, my lord, it may not be permissible for recognition of same-sex marriages.
Just 1 second.
छोड़ दो यार, सोशल वोशल नहीं करना था। Special Marriages Act.
Yes.
Lord, under section 4 of the Special Marriages Act, all sub clauses are conditioned in
That's
addition.
the-
I don't want to repeat.
And what is
it.
the second point, Mr. Umar?
Second point is, my lord, on that as late as 2022, my lord, I have placed 3-4 judgments of your lord, my lord, of the different courts, which, my lord, 2 are Privy Council and 1 is from Hong Kong, my lord, where 2 out of the 3 judgments where similar rights had been claimed, my lord, were declined. And in one of the judgment, constitutional validity of declining this right, such a claim, which was placed before the court, my lord, is rejected. That is, that a provision we say, no, there would not be any recognition to same-sex marriages, which was put in question on constitutionality, is declined. My lord, if your lordship will just have a look at the judge, small note, my lord, I'll just.
Yes.
The provision.
It's like that DOMA, the DOMA.
Page 18.
Yes, my lord.
DOMA was struck down. Here you say DOMA was upheld.
Yes, my lord.
Page
Yes, your
18.
lordship is right.
Page 18 of your submission.
Yes, my lord, if your lordship may just give me, only make a note, my lord, in para 14, we have also relied on section 112 of the Indian Evidence Act in support of the first submission. And then, my lord, if your lordships come to para 16, my lord, which is extremely important.
1-6.
Yes, 1-6 at page 7, where 3 provisions of 3 personal laws, my lord, where there is that ability to procreate, which is one of the conditions in section 4, is a ground for divorce. In all the 3, my lord, personal laws of Hindus, Christians, and Muslims, which is, my lord, mentioned in para 16. And then, my lord,
At the present,
if your lordships rightly, my lord, pointing out to
Those foreign cases you wanted to show.
yes, my lord, page 19 bottom, the Italian Constitutional Court, my lord, where the Article 29 of that, my lord, Constitution, which, my lord, is reproduced at page 11 of the note because a reference is made earlier. Just make a note of, my lord, Article 29, which, my lord, was very wide, much wider than section 4 of our act.
Article
where-
29, where, Mr.
My
Sorry,
lord, if your lordship may kindly see page 11,
21,
page 11 of the note,
right.
Para 21.
Okay, thank you.
page 11 of the note, my lord,
This is that Oliari, the
Yes,
judgment
my
of Republic.
para 21, Article 29, if your lordship may kindly see the second part of it, marriage is based on the moral and legal equality of spouses. So, my lord, by repressing this word spouses when the right was claimed, my lord, that is declined at bottom, my lord, page 19 bottom, going up to the next page. Kindly see para 31. And, my lord, if your lordship permit me, I've kindly come to 20 and 21, extremely relevant, my lord, and your lordship may also keep 2 things in mind. The argument of discrimination and classification, which Mr. Dwivedi had also addressed, I don't want to add. And, my lord, the benefits to flow from such recognition, which, my lord, an argument raised here also, both the arguments raised, both are taken up squarely, my lord, directly, and, my lord, debated, considered, and declined.
You cited Oliari as well as.
And, my lord, yes, my lord, and your lordships have considered Oliari in, my lord, the pages judgment, but if your lordship may kindly.
Para 34 is your Privy Council judgment.
Yeah, and, my lord, Privy Council, in one of the judgment, my lord, just give me a moment.
Of Cayman
That is
Islands.
Page 21, last 2 paragraphs above 32, both the grounds of discrimination and other benefits which flow from such a legal recognition of marriage have been considered. And if your lordships kindly come to 22, this is para 34 is the, my lord, first judgment of 2022, my lord, in by the Privy Council, where, my lord, section 14(1) of Bill of Rights was, my lord, which is reproduced in para 34, and then, my lord, the consideration thereof is up to page 24 of my note, and, my lord, which was rejected. Kindly come to para 36, which is that section 53, my lord, of Domestic Partnership Act, which created a prohibition against such a recognition. It's extremely important, my lord, for your lordship's kind consideration. The Domestic Partnership Act of 2018, where section 53 created a prohibition, the constitutional validity was challenged, and, my lord, after consideration at para 76 and 77 of that judgment, which is reproduced at page 24 and 25, it is rejected, my lord. In Hong Kong, my lord, which is para 37, which is also, my lord, 2022, a similar, my lord, discussion has taken place. Similar contentions have been considered. And if your lordships kindly come to page 27, my lord, para 77, kindly read, I'll just read para 77. Your lordship may kindly have regard to the other portion, and I have to place the judgment copy also in the second compilation. Kindly come to para 77. In terms of access to the institution of marriage, it concerns the special status of marriage, which is a distinct concept from the benefit arising from it. The difficulty or even perceived hardship involved in obtaining the benefits of means of legal challenges does not justify a shortcut bypassing BL 37, my lord, which is Basic Law 30.
All right, Mr. Mahendra Singh. Thank you. Thank you,
Mr. My lord. And judgments are, my lord, enclosed. The full text of the judgment is placed for your lord. I am deeply obliged, my lord.
Thank you, Mr. Mahendra Singh.
Please, your lordships. My lord, I appear for the Akhil Bharat Sant Samiti. I'm not going to repeat anything, my lord. Most of the points are already covered. In fact, I'm adopting, my lord, all the points. I've already filed written submissions. Only 2 points, my lord, I wish to highlight. A, Lord, the concept of marriage in the Indian society is creation of an institution. For example, in the Hindu law, it's a sacrament. Muslim law, it's a contract.
The concept of marriage in Indian society is,
Lord, an institution by itself. Whether in Hindu law, it's a sacrament, so it is a divine angle. In the Mohammedan law, Lord, it's a contract. Now, various facets. Now, Lord, concept of same-sex marriage, therefore, would be virtually like an attack on the very institution of marriage, which has been traditionally known in this country. And Lord, we have to be very clear about it. There is no doubt that in Nautej recognizes the right to privacy. Lord, right to privacy is recognized, but your lordships have seen that, Lord, observation, where they have said, by this we don't mean the marriage, it's the union.
Right. What is
the second point, Lord, that I want to tell your lordships is, if your lordships have a look at the sections 19, 20, 21A of the Special Marriage Act, Lord, if you marry under this law, Special Marriage Act, then it's not connected to the Hindu Marriage Act, but it also provides that the two Hindus can marry. Now, if two male Hindus or Lord, two female Hindus marry thereafter, what implications is going to have on the other law? That also is required to be seen. Creating, Lord, a mere civil union is fine. That therefore there would be no problem about a civil union or a declaration that they need not be harassed, or because it's the prohibition part, Lord, is a different aspect. But creating an institution of marriage itself, giving them all other rights, Lord, will interfere with all other.
Yes.
So you are saying that there is no problem with a civil declaration of a civil union per se? But
civil union, and that already has been given in the right to privacy. By privacy, you may not, in fact, in my written submissions, I have highlighted and I have said so. That declaration of civil union is a different thing. But insofar as creating them as an institution of marriage will be virtually, and number two, Lord, India as a country, one has to see, like Roscoe Pound said, law is a concept of social engineering. It has to keep time. But India has not, my lord, reached that level where, my lord, this institution of marriage can be permitted at this stage. Lord, the rest of it, your lordships would get in my written submissions. I'm not troubling because there are other lawyers also who have to argue.
Thank you, Mr.
I'm obliged,
President.
grateful to your lord.
Mr. Sai Deepak will argue now, or Mr. Manisha will argue this.
Look, the state has filed an intervention application seeking to respond to various petitions praying inter alia for a judgment and judgment declaring the marriage between persons belonging to the LGBTQI community as legally valid in the context of the Special Marriage Act in the Hindu Marriage Act. Lord, my Lord's Ladyship, I've had the privilege of hearing the arguments of the Attorney General, the Learned Solicitor General, and other counsels preceding me. I'll abide by the two regulations circumscribed by the Honorable Court, one being the time constraint, the other being not reading out any judgments. My Lord, I've formulated a few points, my Lord, for consideration of the Honorable Court. But even those, my Lord, I shall not be going into in detail. Let me just briefly
Can you formulate that, Ms. Lavkumar? So we can just
I've formulated them, my Lord. I'll just briefly read it. There's only one point on which I propose to take the Honorable Court, my Lord. My 4 points which I've formulated relate to reading up, reading down, updation of the existing law, governing marriage, especially the SMA, to include non-heteronormative unions would lead to altering of the cultural edifice. You know, substantially already dealt with by the other councils. I wouldn't delve any further into it. Necessity for a wide consultative process and comprehensive deliberation by the legislation, but it also has been extensively dealt with by the Learned Solicitor General. This is what I wish to further, my Lord, highlight, this and the next point. It is not a case of exclusion or prohibition, but a case of non-inclusion in a targeted legislation enacted with special aims and objects. And my Lord, taking this further from the deliberations, as transpired in the court yesterday, tracing any right of recognition by whatever name called, within or outside the framework of matrimonial laws would result in the creation of a new institution, dehorse the democratic process. My Lord, the inevitable ripple effect on numerous legislations, and my Lord, of course, my Lord, submissions with regard to the Foreign Marriage Act would get covered in the submissions already made with regard to the SMA. If time permitting, I'll make a 2-minute submission on that. My Lord, marriage as a socially recognized institution and the foundation of the Indian family unit, my Lord, I wish to submit that it is marriage between a man and a woman is at the core of the family. The Indian society is founded and organized around this concept of the family. My Lord, the rules of marriage continue to evolve, but they remain grounded in organizing of heterosexual relationships. My Lord, the interest of the state, considering the importance of this institution, my Lord, the interest of the state in regulating of marriage is, my Lord, lies in the overarching interest to preserve social order, ensure progression of society in a legitimate manner, and to regulate matrimonial conduct. In that sense, my Lord, marriage as a legal institution is not a private affair between consenting adults. It is a public act between two consenting adults who are then conferred a legal status by the state upon fulfillment of statutory requirements. My Lord, I then would point out that the SMA is part of a wider spectrum of all enactments relating to what we may be broadly calling matrimonial laws, whether in the realm of personal laws, whether SMA, whether FMA, all are heteronormative in structure. My Lord, I have excerpted by way of a table that all these laws carry certain features which would be considered as the core fundamentals or the thrust of the legislation. Namely, all of them refer to as heterosexual unions, all of them prescribe monogamy, all of them prescribe minimum age of marrying, and all of them carry prescriptions of prohibited degrees. They may vary from legislation to legislation, but all of them are uniform in that sense. My Lord, the fundamental of marriage my lord, before my lords, is a matter which has very serious consequences in terms of its depth and breadth, considering that my lords are examining not just the validity of an act, namely the SMA or the FMA. My lords are examining the very edifice of family institution, social structure, myriad of matrimonial enactments, and based on those myriad of matrimonial enactments, my lords have succession enactments, divorce provisions, maintenance provisions, adoption and maintenance. So it's an entire regime which is regulated. And all of it which is based on heteronormative. So it is an entire regime. My lord, looking at the act in isolation, my lord, would not be possible, considering that it is all on the same platform. All heteronomous, all with these embargoes, all having regulatory nature, and all on the same platform. And built on this is entirely a regime of other enactments, and more importantly, social legislation, benevolent legislation, namely for Evidence Act, 113A, presumption, or Dowry Death, presumption, 113B, or my lord, Dowry Death Act itself, or my lord, Stridhan, under the Hindu Marriage Act, Section 8. So there is an entire edifice which has been, which is created around the institution of marriage.
You may read para 6 if you don't mind.
Please, my lords.
Page 11 of your note.
The rules of marriage continue to evolve, but they remain grounded.
Sorry, this is para 6 of page 11, social institutions.
Brief note.
To the written submission.
Para 6. My
After the chart,
Please, give me my...
the chart which you have given,
Yes.
so 2 pages later, this is part of note sub-para 3.
Yes.
Yes, please read that.
My lord, the institution of marriage.
Yes,
The institution-
social
It's
institutions,
PDF 13.
PDF 13, yes.
PDF 13.
11. Printed 11.
13, Baba, come karo.
46
Mera-
pages paper book.
Give me my compilation from there.
Social institute.
Please. Social institutions consist largely of interlocking set of ideas that regulate or affect the way people actually understand and behave across interpersonal relationships. The meaning of social institution matters, and the institutions that bear it serve to structure our experiences and steer them in a particular direction. They define our goals, focus our attention on those goals, and direct us towards them. Changing the public meaning of a social institution leads to changing the institution itself. The concept of same-sex marriage is not within the percept of Indian personal law and legislation. Obliged. So, my lord, I have pointed out that the rules of marriage may continue to evolve, and they need must, but they continue to remain grounded in organizing heterosexual relationships. We have additional grounds for divorce being conferred. Over a period of time, my lord, even 21A seems to is enacted in the provisions of the SMA to ensure that now Hindu laws relating to succession, etc., would be made applicable. And they must evolve, but the normative structure still remains heterosexual. My lord, taking further from that, my lord, over and above the interest of the state in regulating, my lord, I wish to point out to the Honorable Court the argument at which, my lord, the deliberation rested yesterday was with regard to tracing any right with regard to cohabitation into Article 21 as expounded, my lord, in Navtej. So, my lord, Navtej has already granted them the right to cohabit physically, emotionally, sexually, unfettered. My lord, my submission is that contemplating tracing of any right, of any legal recognition of the right to cohabit would amount to creating a new institution outside, my lord, the legal framework. My lord, an endeavor was made my lord, an endeavor was made to read the SMA in a gender-neutral manner. And the Honorable Court went through elaborately provisions as contained in Section 4C, provisions as contained in 4D. 4C was with regard to age, reading in a gender-neutral manner, age. For male, it was 21 years, female, it was 18 years, as sought to be made applicable to gays, possibly yes, to lesbians, yes, but they are not representative of the entire community. My lord, LGBTQIA. So there are.
Could you just, you've used a very interesting expression, juxtaposing the argument of the petitioners to the bouquet of rights.
Yes.
You call this as the sanctification.
That's right.
The sanctification narrative. Could you just explain this in 2 minutes? What do you mean by the sanctification narrative in the context of heterosexual relationships, heterosexual marriages?
My lord, my submission is that this principle of sanctification lies in the fact that the institution of marriage predated any legislation. Legislation recognize this social, cultural, pluralistic acceptance of this heterosexual union across societies, communities, and regulated it in a manner that was most beneficial to public order, sustainability, procreation, ensuring the best upbringing of children. And the regulation does not end at marriage. The enactment provides not only entry points, also exit points, the manner in which you exit, an organized manner, grounds for divorce, maintenance, who gets responsibility for it. So this is an entire genre, a regime created. Now recognition, the petitioners endeavored to look into this SMA as well as the FMA and read it in gender neutral manner. My lord, hypothetically, just taking the example of prohibited relationships under Section 4D. My act, please. My lord, under 4D,
Thank you, Ms.
yes, no, my lord, would my lords, I need to make one important submission. If my lords be pleased to turn to my note, which I forwarded yesterday. I wish to hurriedly go through that. I'll take 5 more minutes. My lord, it's a 5-page note mailed yesterday.
Yes.
My lord, part 3, consequences of any declaration.
Sorry, Ms. Lavkumar, there's a 9-page.
9-page note. I stand correct. It's a 9-page note. I'm only going on part 3. That's all I wish to, my lord, read.
Part 3.
My lord, it would be page number 3. Page number 3, part 3.
Yes.
My lord, any declaration of from this honorable court would have very serious ramifications. The edifice of matrimonial laws and ancillary laws are extremely regulated. Sans any regulatory regime, a judicial recognition would create serious social and legal issues. My lords, please to note, Section 4 had a bunch of regulations, age prescription, prohibition related, prohibited relationships, bigamy, etc. Any recognition would become a law within the meaning of Article 141, and it would be binding on, my lord, the entire judiciary, and plethora of litigation will come seeking recognition. But dehorse this regulatory regime. Tomorrow, my lord, Navtej only talks of consenting adults. What about prohibited relationships? What about bigamy? My lord, there is no regulatory regime. Any recognition dehorse this regulatory regime would have serious consequences. I also point out, my lord, that entry 5, list 3 of Schedule 5, Schedule 7 empowers the legislature to enact laws with regard to marriage, divorce, adoption, wills, etc. This court, my lord, ordinarily would not arrogate it to itself the lawmaking prerogative. My lord, it is further submitted that the petitioner's apprehension is completely misconceived that the parliament would not look into it.
Yes.
My lord, the apprehension of the petitioners in seeking recognition of either marriage, a relationship akin to marriage, or by any name called, is misconceived on the ground that the legislature would decline to examine the concerns of the entire community, seeking legal recognition within the members of such community. And it is only this honorable court which would declare. My submission, this is a circuitous route. Ordinarily, the honorable court would leave it to the parliament. It has various multifaceted dimensions, all to be deliberated, social consensus, a large number of debates, and conflicting views. Those adversarial views are important to evolve, my lord, a consensus on this issue. When to be done, how to be done. Rather than go to the parliament, the first endeavor was read into the SMA. When not fitting into the structure of the SMA, now seek a declaration apart from the SMA, which would have even more serious ramifications. And all arguments which are made applicable in the context of SMA would be equally applicable, my lord, in this context. My lord, would my lords now turn to para 20?
Thank you. I think we'll close it here, Ms.
Just one submission, my lord.
Yes.
By giving a declaration of the nature contemplated, my lord, this honorable court would unintentionally be foreclosing debates in society,
That we have.
foreclose the rights of society to
We have-
determine. And my lord, finally, my lord, such a declaration would hamper the genuine, organic, and sustainable change in society which is reflective of the democratic ethos of the working of the Constitution.
Thank you, Ms. Mulad.
My lord, I conclude by saying that, my lord, it's not a simple class of mere declaration of a result. It has very, very serious ramifications in considering the entire marriage regime and the ancillary social laws which are involved.
Thank you, Ms.
Grateful to you.
Thank you. No, we'll first hear Mr. Sai Deepak. He's got an order which has been given to us. Yes, Mr. Sai Deepak. Can you just formulate what will be your line of
Because with my Lord's permission, given that I have only 20 minutes, and which I expect may not even happen, I'll do my best to simply formulate my position. And as opposed to reading out from anything, kindly allow me to just engage in the bench. Because my written submissions capture my position that's already been shared. So there are two aspects.
Just give us 1 second. We'll just go to your written submission. So as we are arguing, we can also keep a track of your submission.
If I may, Milords, an additional written submission.
Additional submissions or the original one?
The original, the additional is a one-page note, and I'll anyway address it. So my Lords could perhaps refer to the first written submission.
So what is broadly the line of...
Milords, if I may say so. The first law of thermodynamics effectively encapsulates the entire position when it comes to physics, and from there all corollaries flow. So the central position that is effectively placed before my Lords is with respect to the distinction between fetters and powers, which is to say that this particular area which the petitioners seek to espouse before my Lords is an area which falls within either prohibited areas, or is it something that falls within the area for my Lord's adjudication? That is the central issue. And I think that is the forest that is thought to be presented before my Lords. I am here to perhaps unpack a few leaves for my Lord's consideration. The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children. And therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think which arise for consideration before this honorable court. when these kind of petitions are filed. I'm sorry to say this, and let me try and perhaps tone down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. The cause is different from the case. And it is important for the court to seriously consider one aspect here. When there are issues of legislative competence, there's another figure, so to speak, which is involved. And that figure's powers come under Article 111 of the Constitution, which is to say that if a legislative proposal ultimately meets with the consent of both the houses, ultimately it has to go to the Honorable President. And the Honorable President also has the power to recommend amendments to a legislation. Therefore, this is not just a question of legislative prerogative or legislative sovereignty, either from an external or an internal perspective, but there are multiple dramatis personae and stakeholders of this particular equation, the society being the chief. Because ultimately, the petitions raise the question of changing the paradigm with respect to heteronormative attitudes of legislations in general. It is not just about the SMA. Plus, my lords, is not dealing with the religion-specific legislation here, it is the SMA, which means all the more the society's participation when it comes to the SMA is warranted, is mandated, is compulsory. Because at least if it were to be with respect to certain, let's say, religion-specific legislations, it can be said that there is an identifiable group which has a locus to argue here. But when it comes to the SMA, it can't be the argument that only those who subscribe to the values of SMA are allowed to participate in these proceedings. Secondly, as has been already submitted, Section 21 of the SMA has a direct bearing on personal laws. So even with respect to SMA, the society has a right to participate. The reason why the additional written submissions become relevant is because I filed an annexure, which is the Manual for Parliamentary Procedure of 2019, which was published by the Ministry of Parliamentary Affairs. And that particular manual, so to speak, has Chapter 9, which deals with the business of legislation. Close to 30 clauses exist detailing the manner in which a legislative proposal is to be considered in the first place, how the ball is set rolling. And in that, if I may just refer to my additional written submission here, I'll walk my lords through the relevant portion here. Additional written submission, my lords, has a copy been given to the other side? Please hand it over.
We have it here.
Please, my lords. So para 1 effectively has captured my position with respect to Article 111, but the second paragraph is where I placed reliance on the Manual of Parliamentary Procedures. Does my lords have it?
Yes, we have it.
For the benefit of the bench, may I just read this out?
Which para?
Para 2, page 2.
Para 9.2?
Exactly. So para 2, so I'm reading out from the written submission because that okay. Captures.
Right.
And the document itself is annexed. So let me just read out the submission, Millards. May
yes.
I? Please. Does the rest of the bench have it?
Yes, in addition to the above.
Please, in addition to the above. So can I just read out para 1 for the sake of completion? I'm so sorry. May I? Please.
Yeah.
It is humbly submitted that apart from circumvention of legislative prerogative and sovereignty, violation of the doctrine of separation of powers seriously impinges and encroaches upon presidential prerogative under Article 111 of the Constitution. Under the said article, firstly, the Honorable President has the right to receive the bill for his assent after it is passed by both houses of Parliament. This translates to countervailing obligations on the Parliament to present the bill for the Honorable President's assent. Further, under the article, not only does the Honorable President have the right to withhold assent, but also the power to recommend amendments and also reconsideration of certain specific provisions in a certain bill. Now, paragraph number 2. In addition to the above, reliance is also placed on the Manual of Parliamentary Procedures issued by the Ministry of Parliamentary Affairs in July 2019, which contains a specific chapter, Chapter 9, titled Legislation. My apologies for the speed. I'm just trying to keep up with time here. Please. The said chapter spells out in great detail the steps to be undertaken in promulgating a legislation. Critically, clause 9.2 deals with the pre-drafting stage of a legislative proposal, which is divided into 4 broad stages that include consultation between the concerned ministry to which the legislative proposal relates and the Ministry of Law and Justice. Critically, the latter ministry shall review the legislative proposal for legal and constitutional feasibility, validity, as also, and here I quote, necessity and desirability of such a proposal. Clause 9.5 envisages approval of the cabinet followed by an assessment under clause 9.6 of the expenditure involved. Critically, clause 9.7.1 envisages securing the recommendation of the Honorable President after the introduction of the bill, which is different from the assent sought under Article 111. Then, my lords, clause 9.12 speaks of the possible referral of that particular bill to a select committee or a joint committee or for circulation for public opinion. If I may say so, and I say this with the deepest of respect and the greatest of humility that I can command at this point, that a judicial mechanism cannot be a substitute to any of these steps, especially when it comes to such a serious issue. And I draw from Hindu law here that the purpose of marriage or the object of dampatya is a child, is procreation. Now, therefore, comes the central question with respect to all the permutations and combinations which my lords posed by way of circumstances. What happens to a single child? What happens to a single parent? What happens if it's a homosexual single parent? So on and so forth. Allow me to answer this question in a slightly different fashion. Public morality is decided by normative attitudes. The norm is decided primarily by the mainstream. This is not a majoritarian argument. This is a statement of fact in a democracy. Point number two. When normative attitudes are sought to be revisited, to say that those who constitute the norm don't get to participate in this discussion because that particular process and that particular, let's say, dance of democracy is sought to be circumvented by using the instrumentality of the court to secure a certain outcome, I'm sorry to say, defeats the purpose of advocacy. Those who are interested in convincing the society are expected to engage with the rest of the society to make good their cause. The judiciary cannot be a substitute to this particular process because then that effectively replaces societal cogitation with, I'm sorry to use the words, judicial paternalism. That can't happen. 3, the benefit of revisitation of a judgment with respect to such sensitive issues, even if it exists by way of clarifications, I'm sorry to say is not an adequate substitute, it's a suboptimal substitute. Because if the principle that has been established by several judgments is that a judgment is not to be read in the manner of a statute, then there is no precision which can be imparted to the language or findings. And therefore, the principles of statutory interpretation don't apply. So we are left with greater uncertainty.
Basically,
Please, may I? Please. The point that I'm perhaps trying to make, and which is what I'm trying to draw the court's attention to, is that the Nalsar judgment that they placed reliance upon extensively, there is a plus and there is perhaps a downside to it. The plus is the judgment must be read in its context. And the issue was the recognition of a third gender. That was what it was limited itself to. And therefore, to extrapolate the findings of the particular judgment, which primarily concerned itself with self-perception, self-identification in the context of gender identity, to extend it to a marital transaction or a marriage-like transaction is to read a judgment for what it is not. Secondly, there are only 3 in places.
I think we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millets, I'm sorry. I understand. I'm just placing reliance on this. I'm just making
Yes, we understand that these are contexts.
Please.
Whether they're analogies or not is up to us.
My lords, please, Millets. I'm grateful. The second point is, in fact, on a closer reading of this particular judgment, certain inconsistencies emerge between the 2 opinions of the very same bench in terms of what constitutes sexual orientation, what constitutes gender identity. Now, that is natural because there is a discussion that's going on there. It is not to be read in the same manner as a statute. In fact, therefore, the judgment, which doesn't exactly help their position, also points to a certain problem with respect to judicial revisitation of some of these aspects. And the judgment of Arun Kumar of the Madras High Court is actually in the teeth of the submissions being made here, which is to say narrow language being expanded through judicial interpretation contrary to legislative intent and history, is to rewrite legislative history, and judicial reinscription, which is retrospective in nature, may not be exactly permissible. That's one. Then, Milords, the submission with respect to international law, all the general instruments apart, the Yogyakarta principle, specifically clause 24.e, specifically leaves it to countries to decide if they wish to have recognition with respect to marital unions. So it's not as if there is some kind of a binding precedent here, or there's no international instrument that says that you shall. I'm not arguing for it should not be. Kindly let this caveat is important. I'm simply saying, if the door of judicial intervention in this matter is open for one case, even though the cause may be worthy, what does it do for the future? Because ultimately, it's not just a question of one matter. It's a question of the future as well. So therefore, there are specific aspects that relate to the issue in question, and there are general aspects that relate to the separation of powers and societal participation that go well beyond this matter. In light of this, my lords, my only humble submission is that there are other issues to be dealt with, and allow me to just point this out and use this particular forum to advocate only one aspect. Having actually engaged with certain transgender activists and also having worked with them, I know for a fact that one of their biggest problems is trafficking, them being pushed into prostitution, them not having legitimate livelihoods. I am not reducing or dismissing anybody's concerns with respect to what is their priority. Let me clarify that. I'm not making that submission at all. But these are certain Maslow's needs which have to be completed first and which have to be addressed first before we get to the next step. That's all I have to submit. I'm so grateful for the kind pleasement. It's great, deeply obliged.
Now, Mr. Imar Shamshad.
I've submitted 4 pages notes, my lord.
We'll have a look at the note. Can you just identify the most critical point that you want to make?
2 points I'm trying to convey, my lord, because Mr. Sibal, Mr.
Just come straight to the point.
They have already argued. My lord, as far as the matrimonial legislations are concerned, those statutory legislations 50 onwards, even in those legislations, there are scope of customs, practices, which have been practiced for a long time. Undefined practices are part of those legislations. I have cited, for example, only 2 from Hindu related Hindu religion law and 2 from Muslim. For example, section 3A and 29 from Hindu Marriage Act, my lord.
Yes.
Section 3A of Hindu Adoption and Maintenance Act 1956. They take custom within the statutory regime. Those are not defined.
So how do you formulate it?
My lord, even in the statutory regime, undefined customs and practices of community and those who follow religious beliefs have been made part of the statute.
See, 4C proviso of the Special Marriages Act.
My lord.
He itself talks of subject to custom, and then it says how custom is to be, proved.
My lord. So that is there, and we don't know ultimately what custom is finally proved in certain facts and circumstances. That will depend upon case-to-case basis. Same way in Muslim related legislations, my lord. In section 3 of Muslim Women Protection of Divorce 1996 Act, there are practices of Muslims which have been recognized. 1939 Act of Dissolution of Muslim Women, that sets out ground for divorce, but there is a provision which says that other grounds which is acknowledged in Muslim personal law. So those have to come from uncodified sources of personal law.
What is the next point?
Next point, my lord, even if we talk a Special Marriage Act, my lord, reading of section 19 to 21A takes us to custom within 3B, T, 7.3 of Hindu Succession Act. Section 19 to 21, if we read it together, detailed discussion has taken place on this, my lord. It takes us to Hindu Succession Act 3BD 7.3. and they are uncodified customs.
All right. What is the next?
If we go to 27(1)(a), my lord, then that takes us to Hindu Adoption and Maintenance Act 3A, read with section 10, clause 3. So this is one, my lord. Second, as far as declaration is concerned, the declaration that has been sought for from that side, I completely adopt the arguments of Mr. Dwivedi, Learned Solicitor General, Mr. Kapil Sibal. My lord, if your lordship declares this right, I just want to flag one or two problems. Within the realm of personal laws, those that relationship may not be recognized, and it is not recognized in many personal laws. At the same time, we have certain statutory bodies which only regulate religious affairs, like Hajj committees, like certain shrine boards. They only regulate religious affairs. Like if somebody goes tomorrow to Hajj committee and says, I have constitutionally declared right to remain as union, and I want to go on Hajj as couple, married
We'll have
couple.
to wrap up now, yes.
So that I have 2-3 examples that I have set out.
Already look at the...
These are the problems which will be faced by even statutory bodies that you.
All right.
So
Thank you, Mr. Shamshad.
I'm deeply obliged.
Call upon Ms. Priya Aristotle, please. Thank you, Mr. Shamshad. Thank you.
I'm deeply obliged.
Sorry to cut you short, but we are now.
No
Thank you.
problem.
We'll read your note. Yes, Ms. Aristotle.
Much obliged, my lord. I stand here representing a student, Jerusha Joel, and I have 3 lines of argument only, my lord. One is about the history and the marriage aspect, which is social, and about the canvas, which my lord opened up. Normally on a canvas, we want to see who's
You've
behind.
given us written submissions?
Yes, so I will not get deep into it, but how much is necessary. And third is the ASG addressed about the adoptions and the kids. But what about our children who are going to school? They have been receiving a lot of propagation which has been going on, and we just need a little protection for them at this tender age when this is being done on a day-to-day basis in the name of gender clubs. So the first is, as we all know, the word normally used here, even in IPC, was sodomy. The origin of this is the sin of Sodom, which comes from the Bible. And
What's the core of the submission? Tell us the core of the submission.
I just want to bring up the historic aspect.
No, don't give us history. Give us the core of the submission.
Minute, that is all.
Yes.
So I just want to say that we are not following the Victorian law, but it originated 5,000 years back, and it's basically the Jewish law that we follow. And that is how all this was abolished, like adultery, monogamy, sodomy, sati, everything was there, but all that came with the Reformation, which was gone on with it. Now they've come for legalizing it. As long as people do not come to legislate certain things, there are many things that are happening. Like I've visited ashrams, like because my family comes from a set of
One
places
should,
where there are no legality
we got your
at all.
Yeah.
In fact, there must be incest.
It has to be in the form of legislation.
Exactly. But if these people, this group is going to come and ask my lords for legislating it, definitely it's a no. But if it is going to happen behind the doors, nobody is going to be bothered.
Everybody's made that point now. I think we can.
Yes.
Anything else which has not been covered?
Absolutely, my lord. Now going behind the canvas, who is behind the canvas? Internationally, it's not just in this court. I was listening to the the US court arguments, the audio of it. Literally, it's a replica of what's happening there and in many other nations. There are no new submissions that are made. So
all right, thank you, Ms. Aristotle. I think we'll close there. Yes. Thank you, Ms. Aristotle.
Yeah.
Now, what about Mr.
One thing about the UN agenda, my lord. Recently, not very long back, I have submitted my thing, so I'm just not going to get into it. But very recently, they have come with principles, more than 20 principles. And principle number 16 is about consensual sexual conduct. With the new principles coming in, my lords doesn't have to worry about the age factor, whether it's going to be 18 or 21, because UN has come up with a guideline saying that you don't have to, even if they're minors, if they're going to consent for sexual things, that cannot be criminalized. And again, it goes on for 18. It says sexual orientation. Anybody can guide a minor to get into. It comes there, my lord. I have marked it at page 119 to 144 are my UN agenda thing. So again, our children who are going to school, every other day there is propagation of this that is going on, and they need to be protected. In Russia, there's a thing against propagation of...
Thank you, Ms. Aristotle. Now we'll hear Ms. Manisha Narayan Agarwal.
Much obliged.
Thank you, Ms. Aristotle. What's the punch point?
Punch point, Your Lordship, only. Lordship, my punch point is in the first para of my written submissions, Your Lordship. The question I ask myself is, can there be a declaration of, can there be a declaration that an absence of recognition is void? And what will be the consequence of such a declaration, my Lord? Will the consequence of such a declaration be creation of the recognition? And there is only one parallel which I will draw is, there was a time when our statute recognized joint and several liability partnerships, but did not recognize limited liability partnerships. Could someone take up the Partnership Act as law under Article 13(2) and pray to this Honorable Court to recognize, to declare as void the absence of limited liability partnerships?
All right. Thank you, Ms. Thank you. You got the point. Thank you. Mr. Joby Verghese.
Yeah, Your Lordship. Sasmit Patra.
Yes.
I'm representing two organizations. I'm also at a personal capacity as a member of Parliament of Rajya Sabha.
Yes, Mr. Patra.
Your Lordships, two basic points, 2 minutes and I'm done. First, capacity of Parliament. That has not been taken up. We've talked about separation of powers, various things, capacity of Parliament. I'll elaborate on that. Second, role of politics.
Just 1 second, I'll read.
I'm sorry, Your Lordship, I'm having to rush because of the time. But
What was the argument, Mr.?
The argument is capacity of Parliament. I've filed a 3-page submission report in which the 4th para, if you see, there is a table.
Just give us 1 minute. So what we'll do is we'll come back after lunch. We'll give you 5 minutes after lunch. So
Thank you, Your Lordship. Deeply obliged.
I need five to
Certainly.
I will not repeat anything.
Certainly.
Of
course, we're not grateful.
Your Lordship's leave to upload the note in rejoinder, my Lord, which will be the basis for the submission today.
All right. Yes, certainly.
Great.
My Lords, in 501.13, council is appearing online, my Lords.
Come back after lunch.